Hello and welcome to Law It Is. With me, Advocate Nandini Jaiswal. Welcome to episode 2 of season 1. In this season, we're breaking down the harmonizing principles in international intellectual property law. And in today's episode, we'll be understanding the Most Favoured Nation principle or MFN. So, let's get started on our journey from legalese to ease. In the trade of intellectual property, have you ever wondered what if giving one country a special advantage meant giving it to every country? Sounds restrictive? Or maybe the fairest rule possible? In international intellectual property law, there's a principle that prevents countries from playing favorites. It's called the Most Favoured Nation principle, or simply MFN. Let us start with the basic why MFN after national treatment. When we explored the national treatment principle in the previous episode, we asked how should a country treat foreign IP holders compared to its own citizens. However, that question addressed only half of the equality equation. The other half is the MFN principle, which inquires how should a country treat different foreign countries among themselves. If national treatment is about domestic equality, MFN is about international equality. So, what is MFN? The Most Favoured Nation principle means that a country cannot favour one foreign country over another in granting intellectual property protection. If a country gives any advantage, whether in rights, procedures, or enforcement, it must extend that same benefit to all WTO member countries. In simple terms, if one country is favoured, the same preferential treatment has to be accorded to all the other member countries. It is important to note here that the MFN principle does not require extra protection. It requires equal protection among foreigners. Despite its name, the MFN principle is actually a rule against favoritism. It prevents any country from being singled out for special treatment. In that sense, Most Favoured Nation is, in reality, a no favoritism principle. Although the MFN principle originated in international trade law, it was incorporated into IP law through TRIPS, bringing a trade-style equality rule into intellectual property. Where do we find the MFN principle in intellectual property law? You may ask. Look at Article 4 of the TRIPS agreement within the framework of the WTO. It says, with regard to the protection of intellectual property, any advantage, favour, privilege, or immunity granted by a member to the nationals of any other country shall be accorded immediately and unconditionally to the nationals of all other members. So what's the difference between national treatment and MFN? Don't they talk about equality? Yes, both are about equality, but not the same kind of equality. National treatment requires foreign nationals to be treated the same as domestic nationals and prevents discrimination between locals and foreigners. The MFN principle, on the other hand, postulates that all foreign nationals are treated equally amongst themselves. It ensures you don't play favorites among them. Together, they form the backbone of non-discrimination in international IP law. Let's say a country grants a special advantage to one country, substantive or procedural, like faster trademark registration or stronger copyright protection. Under MFN, that benefit cannot remain exclusive. It must be extended to all WTO member countries. One advantage becomes a universal advantage. When we say that the application of the MFN principle is broad, we mean that it does not operate only at the level of written law. It spans across the entirety of the intellectual property system, covering substantive rights, procedural advantages, and enforcement mechanisms. The idea is simple. Every advantage must be shared equally. So, if a country grants any advantage to nationals of one country with the stronger rights, longer protection, faster registration, simpler procedures, stronger remedies, or better access to courts. It must extend the same advantages to nationals of all other members immediately and unconditionally. Let's understand this with a simple analogy. Imagine you're hosting a birthday banquet. You invite many guests and ask everyone to make their own travel arrangements. That's perfectly fine. But now, for one guest, you arrange a special pick and drop service, a luxurious high-end car, and VIP access to the venue. You give them priority entry, no waiting, better assistance, and a completely seamless experience. Can you do that? Yes. MFN does not stop you from offering a benefit. But here's the rule. You cannot limit that benefit to just one guest. If one guest gets VIP treatment, then every guest must get the same treatment. No selective favoritism. Only equal treatment among all guests. MFN sounds strict. If one country gets a benefit, everyone must get it. But is MFN absolute? Well, no. Because complete uniformity is not always practical or fair. TRIPS therefore provides limited exceptions, including pre-existing international IP agreements, certain judicial and administrative arrangements, limited recognition agreements, and in practice, countries also enter into free trade agreements, FTAs. But these are carefully structured. How they are structured to avoid triggering MFN is a discussion for another time. For now, it is enough to note that countries do enter into such bilateral agreements without undermining the core harmonizing principles, because otherwise, a benefit granted to one country could extend to all WTO members. This is where MFN becomes truly significant, because it is not just about equality, it actually shapes how decisions are made in practice. When India negotiates with another country, it's not just thinking about that one relationship. It also has to ask, if we give this benefit here, will we have to give it to everyone else too? And often, the answer is yes. So imagine India agrees to something like data exclusivity, where clinical trial data submitted for drug approvals cannot be used by generic manufacturers for a certain period. Or it agrees to extend the life of patents beyond the usual term. Or it takes on obligations that go beyond what TRIPS requires. Stronger protection, longer duration, higher standards. These may seem like bilateral commitments. However, under MFN, it risks being multilateralized across all WTO members. And that's where the real impact lies. Because now, the question is no longer, do we want to give this benefit to one country? It becomes, are we ready to give this benefit to the entire world? That's why countries tend to be cautious. MFN acts as a kind of built-in discipline. It prevents selective concessions and ensures that any step taken in one direction has to be taken for everyone. At a broader level, this brings stability to the system. Countries can't create exclusive arrangements or selectively favor certain partners. Everything becomes more predictable, more transparent. But there's a trade-off. The more equality MFN ensures, the less flexibility countries have in negotiating selectively. But what if a country wants to say, I'll protect your IP only if you protect mine? That's not MFN, that's reciprocity. Let's wrap up this episode now and keep this conversation for the next episode. Thank you for listening to Law at Ease, where we take you from legalese to ease. I am Advocate Nandini Jaiswal. And if the law felt complicated before, I hope it feels clearer now. Until next time, keep the law simple.